Welcome to this video presentation. My name is Kyle Ingram. I'm an attorney in Washington, D.C. Today's presentation concerns the upcoming federal. So thank you for tuning into this presentation. Today, my name is Kyle Ingram. I'm an attorney in Washington, D.C. Today, I'm going to be talking about the reductions in force that are unfortunately coming for federal employees. And I'm going to cover also the bump and retreat concepts. These are going to be high level. If you have questions about this, you should be reaching out to an attorney to help you figure out what your rights are when these RIFs start hitting. So, as I said before, this is legal information and not legal advice. This presentation explains the technical rules regarding federal reductions in force. While I am an attorney, this presentation is for general, informational, and educational purposes only. It is not legal advice for you. Every situation is different, requires individualized analysis. If you are facing a reduction in force or believe you may be affected by one, you should consult with a qualified attorney who can review your specific circumstances and provide you with legal advice tailored to your situation. Nothing in this presentation creates an attorney-client relationship between you and me. Okay, let's move on. The reduction in force process is controlled by regulation, which is under Title V of the Code of Federal Regulations, and it's split up into these four different areas or conceptual ideas here. The reduction in force process relies on these different concepts, and you should understand them going into the process so that you can better understand how your rights are going to be affected by specific issues within these areas. The largest area here is the competitive area. Depending on how the reduction in force goes, usually within one unit that is being reorganized. We don't know what's going to happen with these reductions in force. We may be talking about entire agencies that are being reduced. So there may not be specific units, but in the classic case, the government will understand that it has to get itself out of some work that it is doing. For example, the Interstate Commerce Commission was shut down in 1982, and all of the employees had to be moved somewhere else or terminated. There was no longer any funding for the agency. That was a reduction in force where commerce had to be, or the unit being reorganized was the entire commission. That would be one competitive area, that whole unit being moved. And so the question is, what level was the person taking that decision at? Because if it was being taken at the agency level, then that would be all of the units within that one agency that are being reorganized. If the decision is being made at a subunit, DHS has multiple subunits, the Department of Defense technically has separate agencies within it, but within those agencies there are multiple units within that. If those are being reorganized, somebody's deciding which jobs to keep, which ones not to keep, then the units underneath that individual are going to be the relevant unit that is going to be reorganized, because people will be spread out across the different parts within that unit. So that's a little complicated, a little opaque. We don't know right now how these are going to proceed in everybody's situation, every agency, every office. It's potentially going to be very different. That being said, there is something that is pretty clear here. The competitive area is also the local commuting area. So within your agency, within whatever unit within your agency is going to be the unit that is being reorganized, it is going to be limited to your local commuting area. That is the competitive area. So you're never going to be able to get outside of your competitive area to bump somebody or to retreat to another position, unfortunately. The tenure groups are groupings under the regulations that identify who is first, second, and third in line for reduction in force. These are the permanent, probationary, and temporary employees. Permanent employees have advantages over probationary and temporary employees, and probationary over temporary employees in any reduction in force. Within those tenure groups, there are subgroups. So there's disabled veterans, those who have 30% or higher VA ratings. We've got veterans, those non-disabled veterans, and all others. So those are groups A, D, A, and B, or I should say subgroups. Within permanent, there are those three subgroups. Within probationary, those are three subgroups. Competitive levels. So within each subgroup, the subgroup is broken up into different competitive levels. And it's not entirely easy to explain in a short video, but basically if the jobs are essentially the same, they'll be grouped together into a competitive level. You'd be looking for the grade and series first to see who is in that competitive level. So 13 1801, GS 13, 1801, 3 for a management analyst position. Could be wrong about that. But those are generally how they will be grouped together. Anybody who can do a job of somebody else without any undue interruption, those get all grouped together. So there might be multiple series grouped in together if there's not going to be a disruption from one person replacing another. There's a lot of litigation around that, so that's just something to remember going forward. So these all come from 5 CFR section 531. So the largest area here is the competitive area. I've made this into a square because it's an organizational unit, and then a geographic area, tenure groups, and other subgroups within that. Within the competitive area, there are the tenure groups I was talking about: temporary, probationary, and permanent. The permanent includes both the competitive and accepted service, but those get split off later. Next is the subgroup. There are 3 subgroups: disabled veterans, and all others. Within those, you've got your competitive levels. That's what I've tried to document here, how those competitive levels are going to be viewed. To the left-hand side are the first to be released all the way to the last. If you look at the left-hand side, these are the individuals who are going to have the most protection in a coming reduction in force. That doesn't mean they're necessarily going to keep a job. It just means that they're going to be the last to let go. Those would be the disabled veterans. As you go down that line, within the permanent tenure subgroup, disabled veterans are last, then veterans, and then everybody who has no veteran status but is a permanent employee. Below them are the probationary and career conditionals and the temporaries, which don't have any rights to sue under the MSPB. Order of business here is going to be going through the temporaries, probationaries, permanents, veterans, and then disabled veterans. And that's going to be by competitive level. So we don't know exactly how they're going to structure these layoffs. If they're going to try to cut 50% of the force, they're going to try to cut certain offices or cut 90% of certain offices. It will depend on how these are structured, but this is the overall regulatory environment in which these are going to take place. And this is important for the bumping and retreat rights. We're going to take a look at this and see how retreat rights and bumping rights work, because they don't work in exactly the same way. I've left a little bit of room here under the competitive levels because there's going to be multiple competitive levels, and that is important to understand because you can retreat down levels and you can bump over and then down certain levels. Competitive levels are not going to be synonymous with GS 11s, GS 12, GS 13, but it's at least on the same scale. So bumping. How bumping works. The general concept of bumping is that somebody else has a job, they don't have as much tenure as you do, and then you're going to bump them out of that job. In terms of releasing employees, is how they determine who is going to be released in which order from first to last. Within the competitive levels, let's say that you've got 20 other people in your competitive level, that they have essentially the same job, the same grade as you do. What the agency is going to do is take your years of service and then add additional constructive years of service based on your 3 most recent performance evaluations. They can add up to 20 years of constructive service onto your actual years of service. So if you have 20 years of service and perfect 5s in your performance evaluations, that would give you 20 extra years. So you'd have 40 total years of service. When you're competing with others in the register, they're going to create this register. It's basically just a list, and they're going to put in what are your years of service plus your years of constructive service, and that's going to give your place on the register. If you've got perfect 5s, you've got 20 years of experience in the federal government, that's going to give you a total of 40 actual and constructive years in your competitive level. So you're going to outrank somebody who's got a 39 or a 38. That's just the start of it. If you can't identify somebody who has fewer years of service than you and potentially performance reviews that aren't as good as yours, it's going to be difficult to prove or even to get into court and to get jurisdiction with the MSPB to demonstrate that you shouldn't have been released or that you shouldn't have gotten the low order of release that you did get. You might be able to show that somebody else should have been released before you. That's the years of service and performance. That's how it's going to be calculated. The agencies are going to do this on their end. I don't know if they've released those registers. It might be available in discovery. So let's go back to bumping, how it works. Concept of bumping is I'm getting released from my position. there's a position that somebody else has that I would like to be able to take, let's bump them out of that position. Now, one caveat about this is we haven't necessarily heard a lot about positions being removed from the roles. So as you probably know, every job has a billet. And if there's a billet for something, that billet can be filled. Sometimes the billet is already filled and they want to open up that billet, so they terminate the employee from that position if they're not performing or if they've engaged in misconduct. So that billet stays even if the person who is performing the job that billet is for is gone. Here we've got slews of billeted jobs that are not being done because the temporary or probationary employees who have been doing them have been fired, unfortunately. How the agencies are going to handle this, are they going to just remove those billets? How they're going to exactly justify not bumping somebody into an open billet that was vacated by somebody who's no longer there? I don't know how they're going to justify that. But at this point, we're going to talk about what has happened in the past, which is typically a much smaller reduction in force. Bumping is a way for somebody whose position is going to be cut. Let's say their billet is going to disappear, but they are still there doing their job. They would like to retain a position with the agency if they can't retain their own position. Bumping allows them to take the job of somebody else in the agency within certain rules and force that person to either bump down to another job or to leave the agency and be terminated. In order to take the position of another employee, to bump that other employee out of the position, it has to be outside the same subgroup. There's a bunch of other rules that go along with this that state that you have to be capable of performing the essential functions of the job. The main point here is that when you're looking at a particular position and you want to know if it is something that you can take, it has to be outside of the subgroup or outside of the same tenure group that you're already in. You can't go within the same subgroup. Okay, so here are those. So you can see the subgroup here. You can take it within the same tenure group or within the same subgroup. So if there's nobody actually doing the position right now, where does that fall on this? I have to imagine that if the billet is open, the job can just be taken. The only issue here is if somebody's currently performing. To the extent that outside of a tenure group means that you could move from the permanent group to the probationary career conditional group or the temporary group to take one of those jobs, you wouldn't lose your tenure because you took it, I don't think. That, depending on the agency, there are going to be jobs out there that these classifications about who's currently doing the job, I mean, these all relate to the individual who's in the job, not to the billet. All of that is open for question at this point. The tenure groups here, as you can see, you could go from the permanent and take a job that was held by a probationary career conditional person, right? So you would bump that person out if you were capable of doing that job, and it's going to meet that requirement that it's outside of your tenure group. So bumping, you move from one end to the other. Okay, so this is the map for bumping. If you are being released, you are allowed to bump somebody who is of a different subgroup or a different tenure group. If you're permanent, you can bump somebody from a probationary career conditional or from a temporary position. The bumping flows in the same way as the order of release. Disabled veterans and veterans, because these are different subgroups, can bump people from the other subgroup. If you're in a disabled veteran subgroup and your position is being cut, you can bump somebody who's a veteran as long as you can do that job. Same thing with the permanent employees and with probationary career and temporary employees. That's what bumping means. So for an example, if you have 3 GS-12 employees and 1 GS-11 position that has been vacated or is available, and there's a reduction in one of the GS-12 positions, going from 3 down to 2, the way that would work is like this. The bumping goes from the most protected to the least protected. This GS-11 position was previously being performed by a probationary career conditional person. In the normal course of things, that person would still be there. They wouldn't just be fired, but these are extraordinary times. So that GS-11 position, let's just pretend that somebody's doing it for the purposes of this discussion, and they're going to get bumped out. So if we have 3 individuals here, one who's a veteran and one who's a disabled veteran, what will happen is that permanent employee will take the GS-11 position, and will bump out whoever's doing that. They will retain their permanent position. It's not stated in the regulations, but I can't imagine you'd have to do a probationary period for taking a job that is a demotion. That way, the person who has bumped somebody else would retain a job, but not the position they were doing before. They can bump down to 3 levels below that. So if he's a GS-12, he could bump down to at least a 9. Those are available jobs. If you're a 12 and you've worked for years or decades to work up to that, and you're bumped down to an 11 or a 9, that's not fun, but it's certainly better than losing your entire job over this. Now, if there were further cuts, what could happen here is that the veteran in the A subgroup would bump out the GS-11 person who had bumped somebody else. So that person could take that job if there are further cuts. The DoD is stating they're going to do 8% cuts per year. That is what bumping is. It's moving out of your subgroup and pushing somebody else out in a less favored subgroup, and then they have to go and try to bump somebody else out. Now, these are all done, hopefully, using these registers, and they will have all of this information from HR, so they will know what jobs are out there and available, what are being retained and what aren't, and they will try to use the information to determine who's capable of doing what jobs. But one thing to keep track of is that HR is definitely not perfect in this regard. They may miss information, they may put things in the register that don't belong there. There's certainly a lot of areas where HR may be doing this incorrectly, and God help them if they're using AI, because we all know that AI is not perfect in doing these things. Registers should be pretty mechanical, but some aspects are not mechanical, such as if you can do somebody else's job, what are the qualifications for that job? There are cases where individuals have been denied jobs even though they could do the jobs because HR did not look in their past history to see if they had done similar jobs. This is a bit more complex than just saying, hey, we've got a job over here, you can take it. You can't take a job that you're totally unqualified for. The agency has to figure out what jobs you are qualified for, and that's going to be based on necessarily limited information. So that's a good reason to have a copy of your official personnel file on hand if you think you're about to be subjected to a RIF. Retreat rights are different from bumping rights. Bumping rights have to do with taking a job that you've never done before. Retreat rights have to do with doing a job that you have done before, or something that is essentially identical to something that you've done before. It might be something that is different from what you're doing right now, but if you've done it before, you could go back to doing it. So even if you're an attorney with the agency, you could go back to being a paralegal. You don't have to do it in the same series or even in the same specific area if you have done it before. They put these in here, I assume, so that people who have done jobs previously can go back to those jobs that they've done well at and continue to work for the agency. To the extent that agencies are being zeroed out here and there's no further employment happening like USAID and CFPB, had, at least at the time of this video in February of 2025, having retreat rights and bumping rights aren't going to help you at all because you need to be within your competitive area. That is definitely within your agency. If your agency is gone, there is no competitive area. An employee can retreat to a position that is held by somebody else if that is a position that they've previously done or it's essentially identical to one that they've previously done. So that just means that if they change the name of the position, but it's essentially the same position, you can retreat to that as long as it's within 3 grade levels of where you are now. So if you're a 15 down to a 12, but you can't go from a 15 down to a 5. And there are actually litigants who have tried to go down more than 3. Now, if you are a disabled veteran, you can go up to 5 levels below. And that's because the regulations have been written to try to keep veterans inside of the agencies rather than to push them out with reductions in force. It has to be within the same tenure group and subgroup. So that means you're pushing out somebody who is in a tenure group that is the same one as yours. The tenure group would be permanent for most people still working at the agency, but probationary can't push out temporary, temporary can't push out permanent. It has to be within the same tenure group and the same subgroup. So unlike the prior example of bumping, when you're doing retreating, you have to be within the same tenure group and the same subgroup. The subgroups are going to be your disabled veterans, your veterans, and everybody else. You can't switch between those to exercise your retreat rights to go back to a previously performed job. In order to be able to retreat to that job, it has to be held by somebody with a lower retention standing. Retention doesn't matter for the bumping rights. There's no question of retention standing because you have to go in the order that the people are being released. Retention is only within your competitive level. Same tenure and subgroup. If somebody's holding that position and that person is a veteran, you have to be a veteran to retreat to that and push them out. Same thing with permanent but non-veteran individuals. So there's no retreating outside of your tenure and subgroup. It has to be within the same tenure and subgroup. All right, so this is the map of how this works. And so essentially what I've done here is I've replaced the competitive levels with different competitive levels. It's not exactly how it works, but it's your grade levels going down. Let's just say it's within one single group here. You could retreat down to an existing position up to 3 levels below, but it has to be within that same subgroup. Here's an example of how a retreat might work. Mark here is previously a GS11 program analyst, and then he moves up to being a GS12 program analyst. He's a GS12 since 2021 to present. Previously from 2018 to 2021, he was a GS11. That's important because without those two pieces being together, he can't retreat back to his position. So career permanent, non-veteran. Right? Same thing for Susan. She's also career permanent, non-veteran. So she's within the same subgroup. She's currently a GS11, so she's got the position that Mark previously held, but she's got less service time, and so she's lower on the register than Mark. It's the exact same position that Mark previously held. So in this scenario, Mark can retreat to this former GS11 position because it's the same tenure group, the same subgroup as Susan is currently. He previously held this exact position, so there's no question that he's qualified for it. In this scenario, Susan has a lower retention standing than Mark does. So because she's got less service time, she doesn't get to outrank him on that. He gets to retreat back to his position and push her out. It's only one grade lower. He's also qualified for the position, but it's very unlikely that Mark wouldn't be qualified for a position that he's previously done unless there's been a change in his overall physical health or something like that. These are some of the rights that individuals have. We're going to have to see how these agencies actually run these. It's unclear right now what they're going to do. The only ones we've seen where they've gone through reductions in force have been wholesale reductions in force at this point. But we're going to see partial reductions in force. We're not going to see the wholesale elimination of the Department of Defense, for example, or the Department of State, but we're likely to see substantial cuts. It's going to depend on how they do it, the order in which they do it, how they identify the jobs that are not going to be done. You're going to need to figure out based on where you are in those retention schedules and in that whole map where you are before you can figure out what your rights are. And then you're going to have to figure out, in comparison with other individuals, where are these positions that are open. I think the easiest one for individuals to prove is going to be your retreat rights, because you previously did the job. It's going to show up in your SF50. You're almost certain that it is something that you can perform. The only real question is, does it still exist, and who is doing that job right now? The job no longer exists. If they've eliminated the entire department or office in which you previously were doing this job, then that's not going to be helpful. And you're going to have to rely on bumping rights. In the cases that we've seen up until this point, certainly in the last 30 to 40 years, we have not seen a lot of situations where somebody might not know what jobs are being retained. Here, everything is so wide open. I think people are going to have a lot of questions about what positions still might be open that they could bump into. And that's going to generate a lot of litigation for the MSPB, because it's going to have to be litigated whether a position is being kept open, who got that job eventually, or who's going to retain that job, where they were in these retention registers, whether they should be bumped or not bumped. That's going to depend on who above them is getting bumped and whether those jobs are being eliminated, kept. There's so many things that are going on all at the same time. If this is happening to you, you should definitely seek out advice from an attorney to see what options you have. There are other options beyond just fighting them on the regulations and whether they're applying the regulations in the right way. There's an open question as to whether these regulations even apply in these circumstances when there are jobs that are available and funded. Hint, the Impoundment Control Act might be an issue here. If these jobs are being funded, is this really a reorganization? Is it just a reorganization to fire employees because you just don't like federal employees? There's definitely an argument somewhere in there. I'm not sure if it's going to ultimately have any legs, but you need to consider that as well. There's also the constitutional arguments when it comes to some of these agencies that are being just wholesale eliminated. That is the presentation here I have for you today. I really hope that we don't have to cross this bridge, but I am sure that we're just going to have to at some point. If this is happening to you, you don't have to do it alone. Please reach out to an attorney. Find somebody who is aware of how these things work and how you can protect yourself, so that if there is something going on that isn't correct, that is not following the regulations, or even it's being used as a cover for discrimination or retaliation, you know what your rights are and how to approach these and fight them. In the EEO office. The EEO office accepts complaints in a very informal way. Going to the MSPB is like going to court. You are going to be treated like a litigant in federal court. They are going to expect you to do things at a fairly fast clip. If there's a jurisdictional weakness, and they're going to start asking you to produce evidence that you have a non-frivolous argument that there's jurisdiction. And those things can catch people off guard. I highly recommend that you have an attorney. As soon as you receive a reduction in force notice, you should start trying to find an attorney who's going to be able to help you through this process. Thank you, and good luck.
Hi, Kyle here. I want to take a brief moment to speak directly to the federal employees who may be facing workplace discrimination, retaliation, or other workplace issues. These matters are complex, and you shouldn't have to do them alone. I offer free 15-minute consultations throughout the week to federal employees to discuss these matters. To schedule your consultation, click on the link in the description below or go to kingramlaw.com to schedule your time to speak with me. Let's discuss how I can help you protect your rights.